98.8%. That is the share of new food chemicals added to the American diet since 2000 that were never reviewed by the FDA. Not reviewed and approved, not reviewed and rejected, simply never reviewed, because companies added them under their own authority, and the agency tasked with protecting the food supply was never told. In 1997, the FDA made that arrangement official policy. This is the story of what followed. In 1958, Congress passed the Food Additives Amendment, requiring manufacturers to prove that new ingredients were safe before adding them to food. It wasn't a radical idea. It was the minimum a functional food safety system would require. But Congress carved out an exception for substances that were generally recognized as safe: salt, sugar, vinegar, ingredients that had been in the food supply for generations without apparent harm. The carve-out was called GRAS. Then the food industry noticed something. The GRAS exception wasn't limited to salt and vinegar. It applied to anything a company could argue was generally recognized as safe by qualified experts, and the company got to decide who counted as a qualified expert. By the 1990s, the FDA was receiving more GRAS petitions than it could process. Average review time had stretched to 72 months, and it was running short on resources. So the agency proposed a solution: a voluntary notification system. Companies could determine on their own that a new ingredient was GRAS, and they didn't have to tell the FDA. They could simply put it in the food. This is not an exaggeration of the policy. The FDA acknowledges in its own documentation that it generally does not have information about undisclosed GRAS determinations. A 2010 GAO report concluded the FDA's process does not help ensure the safety of all new GRAS determinations and recommended reform. The FDA finalized a new rule in 2016. It kept notification voluntary. Nothing substantively changed. Pew Charitable Trust estimated that roughly 10,000 chemicals are permitted in the American food supply, and that the FDA had not reviewed the safety of approximately 3,000 of them. At least 1,000 more had been declared GRAS by companies that never notified the FDA at all. Tom Neltner, who led that research, put it plainly: nobody knows, not even FDA knows, what's in our food. An EWG analysis published in July 2025 put numbers to the gap. Since 2000, food companies petitioned the FDA to approve a new substance exactly 10 times. In that same period, they added 863 chemicals through the GRAS pathway. That is 98.8% of all new food chemicals introduced to the American diet in 25 years, approved by no one at the FDA. In those same 25 years, the FDA pre-market reviewed 7. The consequences are not hypothetical. In 2022, a company called Daily Harvest added an ingredient called Terra flour to a packaged meal. It had self-determined Terra flour was GRAS. Within months, 393 people were sickened and 133 were hospitalized, some with permanent organ damage, more than 40 requiring gallbladder removal. The FDA learned about this through the hospitalizations. The company had filed no prior notification. The agency didn't ban Terra flour until 2024. An ingredient injured hundreds of people before the regulator responsible for food safety knew it was being used. That is not a failure of the system. That is the system. A Consumer Reports survey found that 77% of Americans believed GRAS meant the FDA had evaluated an ingredient and certified it safe. That is not what GRAS means. It has not meant that for decades. The abbreviation stands. The guarantee it implies does not. If you enjoy videos like this, please leave a like and subscribe. It helps us reach our goal of 1,000 subscribers. Thank you. The GRAS loophole governs what the FDA doesn't know about. A separate problem concerns what it does know about and has chosen to leave alone. In 1990, the FDA banned a food dye called Red 3 from cosmetics and topical drugs. The reason was that it caused thyroid tumors in male rats, triggering the Delaney Clause, a law that bars any additive shown to cause cancer in humans or animals. The FDA acknowledged the evidence, applied the clause, and banned Red 3 from lipstick. Then it left Red 3 in food and in ingested drugs for another 35 years. The same clause, the same evidence, the same agency. Red 3 wasn't removed from the food supply until January 2025. The European Union had restricted it in 1994. CSPI found it present in more than 9,200 products at the time of its removal. No one at the FDA has ever adequately explained the gap. Brominated vegetable oil is a chemical used to keep citrus flavoring suspended in sodas. The FDA removed it from the GRAS list in 1970. formally acknowledging it might not be safe. It then permitted it to remain in the food supply on an interim basis for the next 54 years. The UK banned it in 1970, the EU in 2008, Japan in 2010. The FDA revoked it on July 30, 2024. The word temporary carried a very specific meaning at the FDA. Potassium bromate is a dough conditioner the International Agency for Research on Cancer classified as a possible human carcinogen in 1999. The FDA last formally reviewed it in 1973. It is banned in the UK, Canada, the EU, Brazil, and China. The FDA's position since 1991 has been to encourage bakers to stop using it voluntarily. That carries no regulatory weight, and potassium bromate remains legal. Titanium dioxide, a whitening agent found in Skittles, Starburst, and thousands of other products, was banned by the European Union in 2022 after its Food Safety Authority determined it could not rule out genotoxicity. The FDA still classifies it as GRAS. Its most recent General Safety Assessment guidance on the substance dates to 2007. Azotocarbonamide, a dough conditioner present in nearly 500 American bread products from Pillsbury, Sara Lee, Wonder, and others, is banned in the EU, UK, Australia, and Singapore. It degrades into compounds the NIH lists as potential carcinogens. The FDA permits it at up to 45 parts per million. Subway removed it from its bread in 2014 after a public petition reached 92,000 signatures, not because of any FDA action. Butylated hydroxyanisole, BHA, is a preservative used in cereals, chips, and packaged snacks the U.S. National Toxicology Program lists as reasonably anticipated to be a human carcinogen. The EU restricts or bans it over endocrine disruption concerns. The FDA launched a formal post-market safety assessment of BHA in February 2026, roughly 65 years after first approving it. Post-market, in this context, means after the ingredient has been in the food supply for 6 decades, then there are the chemicals that were never intended to be eaten at all. PFAS and polyfluoroalkyl substances, called forever chemicals because they don't degrade, have been used in grease-proof food packaging since the 1960s. They migrate from packaging into food. Studies have linked PFAS exposure to reduced fertility, thyroid disease, certain cancers, and compromised immune function. The FDA had authorized their use in food contact materials for decades. In its own post-market monitoring confirmed contamination in the food supply beginning in 2019. Its response was to pursue voluntary phase-outs from manufacturers. In February 2024, it announced that 3 manufacturers had stopped selling grease-proofing agents containing PFAS, describing this with a straight face as eliminating the primary source of dietary exposure. 12 states had already passed mandatory bans, with California's taking effect in January 2023. No federal agency has set limits for PFAS in food. The FDA oversees packaging, the EPA oversees water. Neither agency has jurisdiction over PFAS in the food itself. University of Sussex toxicologist Eric Millstone estimates that at least 950 more additives are permitted in American food than in the European Union. The gap is not explained by different science. It is explained by a different allocation of risk. The EU requires a substance be proven safe before market entry. Doubt is grounds for restriction. The US requires the government to prove harm before acting. Approved substances stay approved until the FDA can build a case sufficient to survive industry litigation. Red 3 in food for 35 years after its cosmetic ban is not an administrative accident. It is that standard, applied consistently. The failures of policy have a human cost that is worth examining directly. In February 2021, a House subcommittee published a report on heavy metals in baby food. It found that ingredients from major brands tested as high as 913 parts per billion for arsenic, and that baby foods contain up to 91 times the arsenic, 177 times the lead, and 69 times the cadmium that the FDA permits in bottled water. The FDA had finalized a safety standard for exactly one substance in this category: inorganic arsenic in infant rice cereal. Nothing for lead, nothing for cadmium, nothing for mercury in other baby foods. The report noted the FDA had taken no new action in response to earlier warnings. In October 2021, a whistleblower sent the FDA a 34-page complaint about Abbott's formula manufacturing plant in Sturgis, Michigan, a facility that produced roughly 20% of the country's infant formula supply. The FDA did not begin inspecting the plant until January 31, 2022. That was 102 days after receiving the complaint. The HHS Office of Inspector General later found that an earlier complaint, emailed to the FDA in February 2021, had been inadvertently archived and only resurfaced when a journalist filed a records request months later. 4 infants were hospitalized with bacterial infections. 2 died. Abbott shut the plant. The national shortage that followed forced the president to invoke the Defense Production Act. Former FDA Deputy Commissioner Frank Yanis testified to Congress that it was a preventable tragedy driven by the agency's siloed and decentralized food program structure. In late 2023, cinnamon applesauce pouches sold under 3 different brand names were found to contain lead at up to 5,110 parts per million, roughly 2,000 times the proposed international limit. The CDC's final count was 566 children poisoned across 44 states, Washington, D.C., and Puerto Rico. The FDA's own statement acknowledged that it cannot take direct action against the foreign suppliers identified as the likely source because they didn't ship directly to the United States and fell outside the agency's jurisdiction. The regulator of the food supply could not reach the people who contaminated it. The instinct facing evidence like this is to look for a specific villain, a decision maker, a documented cover-up, a moment of obvious corruption. Those elements exist at the margins. They are not the primary story. The primary story is structural, but 2025 Health Affairs analysis found that user fees, paid by manufacturers, fund 66% of the FDA's $2.1 billion human drugs budget and 100% of its tobacco budget. They fund approximately 1% of the food budget. The program that regulates what 330 million people eat every day runs almost entirely on what Congress decides to appropriate each year. The result is an agency that cannot inspect, cannot review, and cannot enforce at the scale the problem requires. So it delegates, it trusts. It calls the trust a system. The revolving door between the FDA and the food industry has been unusually well documented. Michael Taylor cycled from a law firm representing Monsanto to FDA Deputy Commissioner for Policy in 1991, then to Monsanto as Vice President for Public Policy in 1998, then back to the FDA as Deputy Commissioner for Foods in 2009. The specifics of his tenure remain contested. His career path is not. The social architecture of the agency, who comes in, who leaves, what relationships they carry with them, shapes what the institution decides it can do. That is not a separate variable from the funding gap. It is part of the same system. The European Union funds its Food Safety Authority differently, requires manufacturers to prove safety before market entry, and places the burden of doubt on the industry rather than the government. That is not a more scientifically cautious approach. It is a different starting position, one that asks companies to demonstrate safety rather than asking an underfunded agency to prove harm after the fact. In 2025, HHS Secretary Robert F. Kennedy Jr. directed the FDA to explore eliminating self-affirmed GRAS and announced a plan to phase out petroleum-based synthetic food dyes. The announcements generated significant coverage. The substance was narrower than the headlines. The dye phase-out rests on a voluntary agreement with industry, no regulation, no enforcement mechanism, with a target of the end of 2026. Products containing these same dyes have carried mandatory warning labels in the EU since 2010, noting potential effects on children's attention and behavior. The proposed GRAS notification rule is still a proposal on the spring 2026 regulatory agenda, and the FDA has acknowledged it may not have the statutory authority to require notification without new legislation from Congress. The mechanism that allowed Terra flour to injure hundreds of people before the FDA knew it existed is still operating while the proposal is being drafted. Potassium bromate is still legal. Titanium dioxide is still GRAS. The front of package labeling rule proposed in January 2025 sits inside a regulatory freeze. 12 states, led by California, have moved ahead with their own bans, acting on the theory that waiting for federal action is not a strategy. The FDA was built on a premise that is not controversial. The government should stand between Americans and an industry that, absent oversight, will follow its own interests. Every developed country has a food safety authority built on that premise. What makes the American version unusual is that the law, the funding, and the regulatory philosophy have been shaped, across decades, into something that has largely handed that function back to the industry it regulates. and does not have the resources, or in some cases the authority, to verify what industry does with it. Tom Neltner said in 2013 that nobody knows what's in the food supply, not even the FDA. 35 years after banning Red 3 from lipstick, the agency finally banned it from food. Those two facts are connected. The distance between them is the story.